Madayaw at happy kadayawan po sa ating lahat. Ngayong araw na ito pag-uusapan natin itong paano pagtanggal nitong adverse claim. Adverse claim yung pinag-usapan natin during the last video upload ko. We discussed na itong adverse claim is a way na para maproteksyonan yung interest ng claimant on a portion or the whole property itself. Ngayon, paano ito tanggalin kung sakaling hindi naman to legitimate or even if legitimate, natapos na rin po yung claim or interest ng claimant. Yan po ang ating pag-uusapan. Alright, so, how to cancel an adverse claim? Actually, there are two ways. Number one is yung extrajudicial cancellation at number two, yung judicial cancellation. Now, sa extrajudicial cancellation po, simple lang po ang kailangan nating maintindihan nito. Is that you just need to talk. So, kung ikaw po ang registered owner at meron pong adverse claimant, pag-usapan ninyo. In most cases, baka kasi ang problema lang is that meron siyang portion of claim doon sa property na hindi nare-recognize. Let's say, nakabili siya ng a portion or 1/4 or 1,000 square meters from an hectare. Ibawas lang natin. Conduct na relocation survey, ibawas natin, ibigay natin sa kanya para matanggal na yung adverse claim. Alam niyo po, marami pong mga adverse claim na ganyan. In fact, dito sa Samal, yung involving a mother title pa, mother CLOA, nag-lapse na yung period of 10 years. Ngayon, pinagbebenta ng mga members. Kasi sa mother CLOA po, nakasaad lang po doon kung sino yung mga beneficiaries. May mga 200 sila nakalagay doon, covering for a very big area. Let's say, a 500 hectares, tapos nakalista doon kung sino lahat ang mga beneficiaries. Now, this beneficiary sells. Problema, hindi nga mapatituloan dahil ang mother title, hawak-hawak ng kanilang cooperative or ng association nila, and then, matagal pa ang process para i-subdivide ito. Kaya, punong-puno na adverse claim yun. Yung individual claimants na nakabili, sige lang silang adverse claim ng adverse claim. Kaya punong-puno yung papel. But basically, kung merong mga situations ganyan, ordinary issues of partition. Let's say, isa lang may-ari, tapos ngayon, nabenta niya, tapos hindi pa niya nabigyan ng, hindi niya mabigay-bigay ang title doon sa nakabili ng portion kasi nga, ayusin ko muna itong segregation, hindi pa nagawa. Nakalaman ng claimant that ibebenta ngayon ng registered owner. Natakot siya. Baka ibenta ng buo, pakasama yung aking portion. Lagay siya ng adverse claim. Pwede ba yun? Yes, pwede po yun. Now, usapan po, hindi lang doon sa issue na gano'n, sa different kinds, may omitted heir na hindi nasali, tapos na lipat sa iba, tapos makipag-usap ka sa kapatid mo, ayusin ninyo, then you give what is due to that omitted heir, then you could talk and arrive in a settlement. Areglo lang po yan. At nang maareglo po ninyo ang problem is that you could now execute what we call a petition to cancel the adverse claim at ipa-annotate po ninyo doon sa ROD copy. So, in that particular case, yung ikaw po ang registered owner, isama na rin po doon yung original owner's copy, duplicate title na nasa hawak-hawak mo para pag cancel, kasama po doon sa original owner's copy ng title, matatakan din po doon na wala na rin, wala ng adverse claim dahil nga may petition to cancel made by the one who claimed the adverse claim. Ibig sabihin, yung adverse claimant po mismo ang mag-file ng petition voluntarily on his own. Allowed ba yan? Yes po. Kasi siya po mismo yung siya po mismo yung gustong magpa-cancel. Siya ang nag-adverse claim, siya rin magpatanggal. And then that is allowed. And hindi po yan siya i-refuse. That would make the title already clean. So marami po mga situation. In most cases po tandaan natin, it's all about a piece of that property that the claimant wants or in interest na pwede pag-usapan or pwede naman siyang ma-settle. And take note that when it comes to settlement, usually monetary lang po, pera lang po pag-usapan at maaari namang maayos ang lahat. So, okay, I will give you a copy of this para baka gusto niyo i-screenshot, no? So, I will exit for a while. Okay, yan. Ito po yung petition for cancellation of adverse claim. If you'll notice dito, this is actual one that I made sometime in 2022. Ang nangyari dito, yung si Alexander the Great, of course, pinalitan ko yung pangalan ha. Alexander the Great is that siya yung pong story kasi dito. If you'll notice, is ito. Siya daw ang registered owner ng lupa, no? Sa Katitipan, Davao City. Ngayon, on August 14, 2007, nag-execute siya ng affidavit of adverse claim. At napa-annotate niya ito sa original copy ng title on file sa Registry of Deeds for Davao City. Ngayon, in-execute raw niya ito. Under number 5 tayo ha. Ang adverse claim daw was executed to protect the petitioner's interest on the property kasi after the consummation of sale, the former registered owner, yung may-ari, the registered owner before, yung seller, ayaw niya ibigay ang duplicate owners of title at ayaw niya mag-execute ng deed of sale. Ano pala nangyari nito? Kasi ito po si Alexander po. Nasa sa abroad, OFW. Tawag-tawag lang, kaibigan niya yun ba? O sige, bilhin ko yung property mo sa Katitipan, no? Yung 150 square meters. O sige, padala kita ng pera, pan-transfer and everything. Ang kasulatan lang nila is yung email correspondence sila tsaka yung acknowledgement receipt, no? Nung dumating na po si Alexander the Great, ayaw niyang hinihingi niya yung papeles, yung title, at sabi niya, pare, gawa na tayo ng deed of absolute sale para po ma-register at ma-transfer ko ito. Ayaw gawin noong registered owner, yung seller. Bakit? Ang claim niya, gusto niya magpadagdag. Bakit? Kasi matagal daw, bago daw nabayaran. Marami na siyang mga reasons, no? So anyway, they were able to talk in. O sige, sabi ni Alexander, ayusin na natin, bigyan kita ng konti para matapos ito problema. With that, ibinigay sa kanya yung title at nag-execute sila ng deed of absolute sale. So, in this particular scenario, hawak-hawak na ngayon ni Alexander the Great at saka ang titulo na original owner's copy and meron na silang deed of sale. So with that, pinrocess niya na pagdating sa ROD, nag-file din siya sabay nung tinatawag nating petition for cancellation of adverse claim. So if you'll notice po sa second paragraph, verified po siya. Ibig sabihin na kapag verified is that it is under oath, no? Kasi yan ang isa sa mga requirement, no? And pinanotarize sa notary public at pinail doon sa ROD. And yun naman, at naitatak din nga na naging clean na siya. So, take note lang that in this particular scenario, pwede pong assisted by counsel or not. No? Hindi na kailangan man actually na assistant ng abogado. Pero may iba, gusto nila mga assistants. No problem yun. Pwede po. No? Pero ito sa form na ginawa ko, wala. On his own lang ito siya. Nagpagawa siya ng petition for cancellation of adverse claim. So, doon sa title niya, okay, and I'm here, back, okay. So, nakalagay doon yung affidavit of adverse claim niya noon, no? For example, 1, 2, 3, 4, 5, ang entry number. So, dahil sa kanyang petition na in-file, nagkaroon ng new entry. Okay? Entry number 2468, no? Petition for the cancellation of adverse claim under entry number 1, 2, 3, 4, 5, executed by adverse claimant Alexander the Great. Entered in the Notarial Register of Notary Public Ricardo Morales. So, ang mangyayari niyan, kung magkuha ka ng certified true copy, just like this one, no? Just like this one, makikita mo ang annotations na yung adverse claim is, ang next entry niya is, tinanggal na yung adverse claim na yon. Ibig sabihin, malinis na siya on its face, no? Wala na po siyang cloud or yung defect, no? So, nalala po ba ninyo yung cloud on the title na discuss natin the last time? Nasasabi nating defect, no? Na kapag merong klaseng cloud, yung wala pa yan, merong issue ba na parang unresolved issue surrounding the property, no? Na parang nagbibigay duda sa kakayahan ng may-ari ng lupa na ibenta ito. Ayun po ang issue dyan. So, para to remove that defect or that cloud, ito po, no? Extrajudicial cancellation, nag-usap sila, file ng verified petition for cancellation ang si Alexander the Great. Marami pong mga situation, no, sa ganyang pangyayari. Ito is one example lang ito. Pero marami pong mga situations wherein ang adverse claimant mag-file na sila ng affidavit or petition to cancel it dahil wala nang issue. No more controversy between us. Yun man ang sasabi dyan. And there is no more adverse claim to speak about dahil na-settle na namin and i-allow po yan siya. Okay, with that, with this kind of situation is that, ayan, wala na po yung defect, no? Malino na po. Sa akin po, no, ito po ang pinaka the best way, no, to have it canceled, no? Yung settlement. Kaya nga sinasabi ko, may adverse claim. Sabi ko, kilala mo yan nag-adverse claim? Kilala ko po. Sino yan? Ay, ano ko yan, sir? Yung half-brother ko yan siya na. O bakit nangyari? Eh, kasi pag extrajudicial settlement namin, tapos hindi siya nasali, pagkatapos nag-file siya ng petition for settlement of estate. Eh, pagkatapos ng petition for settlement of estate, sinali niya itong property na ito. Dahil ito daw is may share siya. Which is true naman. Sabi ko, ayusin nyo na lang. Kasi isinasali yan sa settlement of estate. Sinasabing part daw yan sa mana niya, sa mama niya, na hindi pa nasa. Pero sir, ang nangyari sir is wala pa man, nabayaran na namin ng estate tax. O di okay lang. At least you will be able to settle it with him na hingin mo lang ng share niya para sa estate tax payments ninyo, no? So, yun nga, everything can be talked about, no? If the parties will only be willing to talk, okay? Alright, so number 2, itong judicial cancellation. Ano ba itong judicial cancellation na ito? Well, as usual, judicial korte tayo. Under sa PD 1529, itong property registration decree. Ito kasi ang property registration decree, ito yung nagbibigay ng basis, no? Legal basis sa pinag-uusapan natin ngayon, no? Ano ba itong adverse claim? May dalawang bagay sila dyan na pamamaraan, no? Is pwede po yung speedy hearing at saka yung regular hearing. Yun po, no? So, ibig sabihin kung judicial ay kailangan nang pumail ng kaso doon sa naapektahan para patanggal yung adverse claim. For example, ikaw registered owner ng property tapos may nagpa-adverse claim. Eh, sabi mo, hindi naman to tama tong adverse claim niya, mag-file ako ng kaso sa court. This is frivolous, this is not true, this is incorrect. File ako sa case sa court, no? So, take note that sa property registration decree, ito po ang sabi. Section 70, no? Ang adverse claim shall be effective for a period of 30 days from the date of registration. Alright, so pagka-register po niya or pagpa-annotate po niya, 30 days daw ang effectivity nito. Ano ibig sabihin yan? Discuss ko kung ano yan, ang meaning yan. But first, we have to understand that in-emphasize po na kapag mag-file ka ng petition bago mag-lapse ang 30 days, no? Speedy hearing ang mangyayari. Ibig sabihin, pagtawag ka ng court ng paspasan, tatapusin yung, parang hindi naman summary procedure, pero it is, ang tawag kasi sa batas is speedy hearing, no? Ang mabilisan yan, baka malamang position paper lang yan, no? Para the judge will order a speedy hearing and questions now upon the question of the validity of the adverse claim, kung valid ba o hindi. At biglang pwede siya mag-render ng judgment na pwedeng just and equitable under the circumstance, no? Now, if the adverse claim is adjudged or decided to be invalid, mag-o-order siya na ipa-cancel ito. Sino-orderan niya? Ang registry of deeds, no? Where the property is located, no? And where it was registered, no? And pag makita rin niya na frivolous, no, yung kalokohan yung pag-adverse claim, aside from the fact na later on meron po tayong remedy for, lalo na kapag perjurious yung pagsisinungaling, pwede tayo maka-file ng falsification or kung nag-testified siya sa court is a false testimony. However, for that frivolous thing pa lang, on that particular proceeding sa petition, pwede po siya pabayarin ng fine, no? Yung adverse claimant na hindi naman totoo, frivolous, kalokohan ng paggawa niya. Alright, and kung sakaling mag-lapse na po, no, the petition filed after 30 days, okay naman. Kaya lang, it will be a regular hearing, hindi na po speedy hearing, no? Ang akin kasing ang experience ko, hindi kung na ma-push ang speedy hearing. So, papadala ng summons with complaint, ada petition, summons sama yung petition, pagkatapos papa-answerin yung kabila, pagkatapos magta-trial, present ka ng evidence, no? So, in most cases, pag klaro naman doon sa papeles, ang mga kompletong papeles at saka ebidensya, there is nothing to go for trial na, is pwede ka mag-pray na decide na lang or judgment on the pleadings based on the documents presented para lang mas mabilis, no? Kung nakikita mo na meron kang chance, no? Malaki ang chance mo manalo ka kung mag-judgment on the pleadings ka na lang. Alright, now ito ang question, no? Ano ibig sabihin nitong period of 30 days from the date of registration? It will be effective for a period of 30 days. Ibig po bang sabihin na pagka after 30 days is wala nang effect, ineffective ng adverse claim, at ibig sabihin okay na ito, yung zero, nada, wala na siyang effect. So, in the case of Sanojas versus Court of Appeals, no, ito ang landmark ruling, no, ng Supreme Court. Pero inexplain po ng Supreme Court dito na hindi po ibig sabihin na kapag 30 days lang effectivity ng adverse claim. In fact, the rule requires that kung sakaling maglampas ta sa 30 days, dapat mag-file ka pa rin ng verified petition sa court para ipatanggal ito. So, it still remains effective. Kasi ang issue doon, parang ganitong story noon merong na itatak siya na adverse claim doon sa property. Kung bagari, buyer siya sa property na yon, nagpa-adverse claim siya for some reason, malamang baka hindi binigay ang title sa kanya and everything, nagpa-adverse claim siya. Ngayon, nung after a while, ito palang property na ito is subject po ito sa isang kaso. So, nagkaroon po ng levy on execution on that particular property. Ibig sabihin, binenta po for public auction. Ngayon, pagbenta sa public auction, dahil yung dating registered owner siguro merong hindi nabayaran or anything, so nilevy on execution. Yun pong meron pong nagbid. Pagbid niya, sabi niya, ako na ang may-ari. Kasi kahit na may adverse claim na nakatatak dyan na nauna, sabi niya, ineffective din kasi lampas na sa 30 days. So therefore, parang wala yan. Therefore, ang pagbili ko ngayon, valid na and akin na yan. Sabi ng Supreme Court, no, you cannot do that. Because that particular statement in PD 1529, Property Registration Decree, hindi nangungulugan na wala ng visa ang adverse claim kahit na after 30 days. It still has effect, no? Kaya nga, ang dapat na gawin mo para matanggal yan is to file a petition in court, no? For a verified petition to cancel it, no? Kung hindi maayos sa extrajudicial cancellation. So, ang nangyari, so ikaw, pagbili mo niyan sa public auction, nakita mo may adverse claim, hindi ka innocent purchaser for value. And therefore, mangingibabaw pa rin yung adverse claimant's interest over doon sa levy on execution buyer. Okay? So, yun po ang parang ganun ang kwento na which I would like to discuss with you. No? So, sabi ng Supreme Court, under the law, the adverse claim shall be effective for a period of 30 days from the date of registration. But it does not follow after the lapse of the said period, it has no more force and effect. The adverse claim shall remain annotated and continue to be alien on the property until the same is cancelled through a verified petition in court. O, see? So, it will continue daw to be alien on the property. Ibig sabihin, parang claim of interest on the property at continue siya ma-annotate at patatanggal lang ito kung mag-file ka ng petition sa korte. Alright? Sige. So, suppose na grant, no? Dahil nga, frivolous or wala nang effect yung adverse claim na yon, then in that particular sense, so, ito mangyayari, no? Di ba, may entry ng adverse claim, no? So, nangyari na yung registered owner, for example, naka-file, kukuha ka po ng decision na final and executory decision, no? Wherein the court said that ika-cancel yung adverse claim. Okay? So, Pag meron ka na noon, bigay mo sa Registry of Deeds para ma-annotate ang decision at ito ilalagay nila. Ayan. For example, entry number 2468, decision of the Regional Trial Court Branch 3054 under civil case number CC-2002-65789 dated March 11, 2022, issued by Honorable Maximo Omixham, directing the cancellation of adverse claim annotated under entry number 12345. And of course, pipirmahan niya ni Registry of Deeds. So, yung cloud on the title again, mawawala yan, no? Ibig sabihin, it becomes now a clean title. Okay. Yung cloud, no, it as if parang yun po ang defect, no? Na, yun nga, nagbibigay duda. Pag may ganyan naman, kung ikaw ang buyer, nag-judicial, ayoko magbili. Delikado pa ka. Bakit ko yan bibilihin? Na meron palang adverse claim yan. Alright? Okay. So, pagpatuloy po natin ng konti, no? Medyo mapunta tayo ng konti-konting discussion pa na baka makatulong sa better understanding natin dito sa difference between adverse claim at saka lease pendens. Okay, may kaibahan ba yan? Ano ba itong adverse claim? Alam na natin, no? It is a claim and you annotate, no? For a part or portion or the whole of the property dahil may claim or interest ka. Whereas ang lease pendens po, pag may kaso po na involving that particular land, pwede ka mag-file po ng litis pendensya, no? Notice of lease pendens po doon sa Registry of Deeds. Ang gagawin mo lang po is that kukuha ka ng copy ng complaint, tapos merong tatak na na-receive ng court, i-attach mo yun sa letter mo, mag-notify ka na may pending case. Yun lang. Dana, no? So, ano po ba ang difference, no? Well, ito po ang sabi ng Supreme Court in Valderrama versus Arguelles. Maganda po itong kaso ito. Basahin po natin, ha? I just want to discuss to you step by step, no? There is a main difference, no, between the two. Sabi ng court is the adverse claim protects the right of a claimant during the pendency of the controversy. Ibig sabihin, wala pang kaso, yung meron pang controversy sa kanila, protektado na yung adverse claimant. Okay. Whereas, pagdating po, no, dito sa notice of lease pendens, it protects the right of the claimant during the pendency of the action or litigation. Ibig sabihin, kung nag-notice of lease pendens ka, so may claim ka, it will protect you during dun sa kaso, kung pending pa at nagpapatuloy pa yung kaso. So, yun ang primary difference nila, no? And sabi nga, both of them protects, no? Parang shield ito or barrier ito. However, itong adverse claim is more kasi siya sa alien, no? Yung talagang claim of interest on the property. May alien, no? Whereas ito pong lease pendens, it is just a notice na may pending na kaso. Hindi ibig sabihin na may lien ang isang claimant doon. Malamang baka wala siyang right or interest, no? So, para sa akin, ang observation ko at saka parang ine-emphasize din na sa Supreme Court na mas mabigat po ang adverse claim. Kasi it shows your lien, no, on the property. Whereas ang lease pendens po, it's just a notice na, may pending na kaso ito. It's just a warning to everyone who will transact na may pending na kaso ito. It may or may not be include this particular kind of lien na adverse to registered owner, no. So, and ang sabi pa ng Supreme Court dito, ito, ang adverse claim daw may only be cancelled upon the filing of petition before the court, whereas a notice of lease pendens may be cancelled without a court hearing. Totoo naman. Kasi pag matapos ng kaso, say, nanalo ako, tapos yung natalo yung nagpatatak ng notice of lease pendens, or the other way around, ako yung nagpatatak, nanalo siya. Well, the winning party, the victor, could always write, no, a letter to the Registry of Deeds na meron ng decided case, no, and the lease pendens has been should be removed, no, kasi nga meron ng decided case which has attained finality. So hihingi ng Registry of Deeds yan, sige, bigyan mo ako ng decision. At saka yung certification ng korte na final and executory na ito na wala ng appeal, wala ng MR, done, nada. Tapos na talaga. Lampas na. So, pag makita yan siya, i-attach din doon. Ilalagay din, annotate din ng Registry of Deeds na, okay, there is no more case. There is no more pending case because it has already attained finality ang desisyon ng korte. Annotate niya yung desisyon, case number, at saka yung date ng desisyon. Okay? So, yan po ang difference ng adverse claim and lease pendens. No? So, with that, I would like to discuss, no, bakit nga, sabi natin, mas mabigat si adverse claim because you are enforcing a claim or interest on the property. Kaya nga, stricto po ang requirements. No? Ito po ang requisites niya to consider yourselves na pwede ka mag-file ng adverse claim. Okay? Number 1, ang adverse claimant, no, yung magpa-file ng adverse claim, kailangan must state the following in writing. Nakasulat talaga, ha? Okay. Number 1, his alleged right and interest or interest. Now, bakit, ano yung right mo doon property na yan? Ano po ang basis mo at nagsasabi mo may interest ka dyan? May claim ka. So, it may be through a contract. No? It may be through the fact that you have a hereditary right. Okay? It might be a unregistered contract, but it is a consummated one. Okay? Katulad ng sale. Kasi sa sale transaction kasi, pwede kasing hindi notarize Yung piece of paper na nagbentahan tayo, that is recognizable, no? And when you demanded now for a execution of a registrable deed of sale, yan nga, yung kay Alexander the Great, ayaw niyang pumayag pagkatapos hindi rin niya binigay ang title, delikado, baka nga mabenta sa iba. So, para maprotektahan yung pagmamayari mo or your claim or interest mo doon, yun na, file ka na adverse claim. So, that is your alleged right or interest no, na isusulat mo sa affidavit. Alright, number 2, ano pa? How and under whom such alleged right or interest is acquired. Paano mo nakuha yung karapatan na yun? Nakarapatan na yun, nakuha mo, o yung right mo na yun, or yung claim mo because I bought it. Okay? Or, ako, tagapagmana. Heir ako. And I was omitted because of the sales transaction. Nangyari po ito, nag-arise po itong pangyayari is after the registration, kailangan ko ilagay ang aking adverse claim para maintindihan po na hindi ako dapat iwala dahil meron akong share dyan. Okay? Parang ganun ba? And of course, yung of course, the description of the land, at saka yung saan located, ilang square meters, no? Tsaka yung certificate title of number. Kailangan ilagay natin, no? Number 2, requirement po is the statement must be signed and sworn to before a notary public, no? Dapat panotaryuhan ng legitimate notary public, hindi po yung notary public sa bangketa, ha? So, kailangan po, para maging registrable po siya. Remember yung discussion natin on defective instruments notarized by pirmatologists, notary publics na hindi naman pala, or maraming defects sa kanilang notarial procedures or protocols under the notarial rules, hindi nila na-follow. Delikado tayo doon. Okay. And number 3, the claimant should state his residence or the place to which all notices may be served upon him. Ayan. Siyempre, ilagay mo kung saan ka dapat makontak kasi kung may adverse claim ka, para pwede ka pong sulatan ng korte or ng registry of deeds or even doong registered owner kung saan yung complete address. Hihingin po yan ng registry of deeds without which hindi yan i-register ang adverse claim mo. Alright? Now, take note, at ito po ang pinaka-importante sa lahat, that there be no other provision under Presidential Decree 1529 to annotate the person's claim except through the annotation of an adverse claim over the subject certificate of title. Ano ibig sabihin nun? Lalim pa na English, no? Diretsoy lang natin, no? Kung wala na ba daw ibang paraan pa under the provisions ng property registration decree, hindi ka na maka-register ng ibang bagay, wala ka na talaga ibang, and your only recourse is to do an adverse claim, ayan, then, ito na lang po ang kaya kong gawin, adverse claim. Okay? Now, if this has been complied, all of which, itong 1, 2, 3, 4, ang Registry of Deeds, pagtanggap po nito, ministerial duty po nila na tanggapin yun at i-annotate. Wala po silang discretion to deny it. Okay. Kaya lang, maraming natutumba dito sa number 4. Tingnan mo ito, for example, pagsulat dun sa affidavit nakalagay doon, meron akong deed of sale. Nabili ko ito kay seller. Ang deed of sale namin is just a piece of paper. And hindi siya notarized and sulat kamay lang. While under the law, it is considered as an evidence of sale and the sale is consummated, sabi niya sa affidavit niya. Nevertheless, when I requested from him to execute a formal deed of sale, yung registrable naman, notarized ng lawyer, he refused. While the title is with me, sabi niya, I demanded from him to execute a final deed of sale but he refused. Therefore, I am registering my adverse claim. Hindi deny yan. Bakit? Nasa iyo ang title. There is nothing to be afraid of ng double sale kasi ano man ang gagamitin niyang gagamitin niyang titulo para ibenta yun. Sino ba, wala man siya mapakitang titulo kung ibebenta niya ulit. Kaya nasa iyo na eh. So ano po ba ang remedy mo? Well, ang remedy mo under the law is to file a specific performance to compel him to execute a registrable deed of sale. Yun ang remedy mo. So therefore, yun ang gawin mo. The moment that is granted, saka mo siya, pag once meron ng order sa kanila to compelling him to execute, or kahit hindi siya mag-execute, talagang matigas ang ulo, makontempt na siya, the court will issue the conveyance of that, no? Para po mailipat ang title sa pangalan mo. But you cannot do it through an adverse claim. Okay. Another scenario nakita ko, when an heir happened to see an extrajudicial settlement of estate. No? Pagkita niya dun, wala ang pangalan niya. Mga kapatid lang niya ang nandun. File kagad siya ng adverse claim. No? Hindi yan itatanggapin ng Registry of Deeds. Bakit? Hindi pa man na natatrabaho yung extrajudicial. Hindi pa nga napaprocess eh. Hindi pa nabayan o kahit nabayan, hindi pa dumating sa registry. So kumbaga, yung issue on being omitted has not yet technically happened that would affect your rights. Papel lang yun. Which pwede naman yung ulitin kung sakaling nakita mali yun, di ba? Or makapagreklamo. Kasi ibig sabihin, kung consummated na at nailipat at let's say, naipangalan na sa kanila tapos hindi siya nasali doon, then that is a process wherein now you could register your adverse claim on the property. And at the same time, later on, you could also file a case for cancellation of title. No? Kaya nga, there is a situation wherein an unomitted heir may question it kapag na-consummate na ang pag-umit sa kanya. Yun ang ibig sabihin. No? So, pwede yun. No? Although, meron din siyang remedy to file a cancellation of title, etc. Tapos mag-list pendens siya, pwede rin yun. No? Kasi, it can go together eh. Adverse claim and list pendens. No? Walang problema, pwede pag magsabay. Hindi, kasi iba nga sila eh. Iba-iba sila. Hindi naman pwedeng isa tapos kung may adverse claim, hindi ka na makalispend. Hindi sinasabi ng batas ganun eh. Pwede sila magsabay. So, meron din, no? Meron din ako na situation na nakita na ito, extrajudicial ito. Hindi na to siya nagdaan ng court, no? Wherein, yung lessee, 1980s pa, nagpa-annotate siya ng adverse claim on the ground that yung lease daw niya, kailangan i-annotate. More than 10 years yung lease eh. So, hindi man ibigay nung registered owner actually, yung registered owner ng client ko, ayaw niya bigay yung title. So, nagpa-register siya ng adverse claim. Ngayon, nakikita gusto na ibenta ng client ko, ngayon, 1980 pa eh. Ngayon, 2024 na. So, niya benta. Hindi niya mabenta dahil may tatak. Sabi ko, mahanap mo ba yung lessee? Sabi niya, yes, mahanap ko pa po. Sige, magpatagawa tayo ng ng petition for cancellation of this adverse claim at i-file lang natin sa Registry of Deeds. Kasi siya naman ang pumirma. Tapos sabihin nyo, expired na, hindi na na-renew, etc. Then there is nothing to claim anymore because nag-lapse na yung period ng kanyang lease. No? Now, kung sakali sabihin nyo, hindi ko na makita, sir, 1980 pa, ang tagal-tagal na, paano, ano gawin ko? Wala tayong choice. We have to file a case in court to file a petition to cancel the adverse claim, alleging na nag-expire na. In court naman, papasagutin yung kabila. Kung hindi magsagot, at least it will resolve the complaint based on your complaint or your petition na pinapakancel mo, and you produce evidence na talagang hindi na tuloy ng renta. In fact, sabihin mo, okay, nandito na ako nakatira, wala na occupancy, there's nobody here using this property anymore. Okay? So, yun ang mga ways, no? Medyo hindi naman kaya ako na-discuss ito, it's a bit complicated really, no? Especially for layman na to fully understand how it is done. Pero ang gusto ko pong maintindihan ninyo doon is that ito po yung process. Ito po yung mga bagay-bagay, no? I do not expect you or us or me and everyone else to be expert on this kasi each and every situation are different, no? It may be that hindi pwedeng adverse claim and we have to file a case in court para mag-dispendence tayo, or pwede tayo mag-adverse claim, then later on mag-dispendence tayo. But that kind of technique and strategy, dun po yung sa lawyer. Pero at least, gusto ko maintindihan nyo na ito po yung mga requisites needed po. Alright, so with that, thank you so much, and of course, happy Kadawan. And 1 week so celebration namin dito sa Davao City. Thank you so much for listening, and have a nice day ahead of you guys. Bye-bye.